we've got the breaking news that a federal judge in New Hampshire has now entered a nationwide injunction to block Trump's executive order from January 20th of this year that would effectively ban birthright citizenship for a slew of citizens in the United States. So let's tackle what we know so that you can be up to date. So the oral arguments were done today, as in Thursday morning before this federal judge. And the group of plaintiffs in this case were attempting to get not only that nationwide injunction put into place, but also the certification of an entire nationwide class in this lawsuit to be able to move forward against the Trump administration in terms of that executive order. Now, this lawsuit was filed on June 27th, immediately after the United States Supreme Court entered its ruling basically saying that nationwide injunctions were not applicable in certain situations, effectively allowing Trump's executive order to move forward. But you'll also remember that here at the Katie Phang News Channel, we discussed the fact that that decision by the Supreme Court had a 30-day window, a 30-day stay, effectively saying that, hey, if you're going to seek relief from another court, you better do it within that 30-day window. And that is exactly what this group of plaintiffs did. So let's talk about it. Who were the plaintiffs? Well, I'm going to say with pride that Democracy Defenders Fund, of which I am a part, as well as the ACLU and LULAC and other amazing organizations, represented this group of plaintiffs. The proposed class, the one that was the proposed class, included babies that were subjected to this executive order, but it also included more people. It was brought on behalf of pregnant immigrants, as well as immigrant parents and their infants, to be able to be deemed to be this class that needed to be protected from Trump's executive order. Now, the judge in this case did enter that nationwide injunction, but limited it, and we're going to get into the language of that in just a minute. But I wanted you to understand who the group of plaintiffs are so that you understood kind of who was bringing this lawsuit. Now, let's start with specifically the executive order at issue. I want to remind everybody, this executive order was dated January 20th, 2025. It was entitled Protecting the Meaning and Value of American Citizenship, which is a bullshit title. And it basically starts with a reiteration of the 14th Amendment. People, this is in our United States Constitution. The 14th Amendment is clear. It states as follows, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Period. End quote. That's it. It's very clear. The language on its face could not be clearer. Now, the executive order from Donald Trump did the following. It basically said, quote, the privilege of U.S. citizenship does not automatically extend to persons born in the United States, one, when that person's mother was unlawfully present in the U.S. and the father was not a United States citizen or a lawful permanent resident at the time of that person's birth, or when that person's mother's presence in the U.S. at the time of their birth was lawful but temporary, for example, visiting the U.S. under a visa waiver or visiting on a student, work, or tourist visa, and the father was not a U.S. citizen or lawful permanent resident at the time of that birth. So those are the particular groups of people that were affected by Trump's executive order. It also says that it would apply only to people who are born within the United States after 30 days from the date of this order. So the date of this order was January 20th. It had that 30-day window, but then the lawsuits ensued until the Supreme Court did on an emergency application what it did a few weeks ago. Now, let's talk about this lawsuit in New Hampshire. As I said, it was brought on behalf of a group of plaintiffs seeking class certification. And the argument that was made was this particular group of people needed to have a class certification achieved, as well as a nationwide injunction to protect them from Trump's executive order as the case is progressing. I will also remind you that the Supreme Court of the United States a couple of weeks ago did not address the substantive issue of whether or not the 14th Amendment was to stand. I always want to remind people because the Supreme Court specifically didn't address that, in large part because the federal government actually didn't address that, because the federal government knows that it's going to lose on this issue of the 14th Amendment. The ruling by the judge, Joseph LaPlante, was made from the bench. What does that mean? That means that at the time when his ruling was entered, he did it orally from the bench, and he said a written order was to come, and we got our copies here of those written orders. But at the time of his ruling, he did it from the bench, meaning that he made the declaration without actually reading from an order or issuing a written order. The government was seeking that the entire class not be certified, one, and two, saying that the class was too broad that was being sought by the plaintiffs in this case. The judge has given a window of 7 days for the government to appeal to the First Circuit Court of Appeals. And listen, it's the Trump administration, so we know that's going to happen. And we'll get into the specifics in a minute. But the judge understood that an appeal was going to be coming. But I want to talk about the timing of that vis-a-vis what the Supreme Court said in its own 30-day window, and we're going to kind of see how the machinations turn out here. But of course, remember too, when the United States government was arguing in the what we call the CASA case, right, the one that went to the United States Supreme Court, when they were arguing that CASA case, they basically told the Supreme Court, the government did, that it thought that nationwide classes was the way to go versus nationwide injunctions. So it'll be interesting to see whether or not they are disingenuous in the legal arguments that they advance if they choose to appeal this decision. But as we talked about, that 7-day window that this federal judge just gave the government to be able to appeal, it's still well within that 30-day window that expires July 27th that the Supreme Court gave to basically let people go to court and try to get their nationwide injunctions. So there is protection that's baked in there. So that's some other good news. I want to actually read to you the statement that was given by Tiana Mays, the legal director for Democracy Defenders Fund. She said, "This decision today is a victory for our plaintiffs and millions of families across the country who deserve clarity and stability. The fight to uphold the guarantee of birthright citizenship is far from over, and we will continue to advocate to ensure we keep that promise." Let's dig deeper, please, into the orders that were entered by Judge LaPlante so you can see what the language is that is at stake here that will be the grounds upon which an appeal would be made if the Trump administration does an appeal. Let's start first with the order granting the motion for class-wide preliminary injunction. You know what? Actually, no. Let's start with a provisional class certification so you understand how this came to pass. If you'll remember, class was in session on Substack Live and on YouTube when myself and Steve Vladeck dealt with this issue of classes, like class actions last week Friday, because we knew it was important for you all to understand how class actions operate. And as we described, there is a Federal Rule of Civil Procedure 23 that if you pull up on their internet and you were to follow along from the internet of Federal Rule of Civil Procedure 23, and you read this order, you'll see that it actually matches the language of that federal rule. So Judge LaPlante grants the motion for provisional class certification and appointment of class counsel. So what does that mean? Provisional means it's obviously, for the time being. And in fact, the order says this certification is provisional, final relief is not granted at this time. That means that we're not all the way to the end of this case. And so right now, the class certification is temporary, which again happens. This is not unusual, just to let you know. The judge in the order then goes on to say that Federal Rules of Civil Procedure 23A and B2 are satisfied. The requirements are satisfied. The plaintiffs have demonstrated that the members of the proposed class are so numerous that joinder is impracticable, meaning that there's so many people that are affected by this executive order that the class certification makes sense. 2, there are questions of law and fact that are common to the class. Again, the idea that commonality is there, that the issues that are at play, not only of law and fact, are satisfied by this proposed class. 3, the claims of the petitioners are typical of the claims of the class members. Again, the claims have that similarity. They are typical of those of the proposed class. And 4, petitioners and their counsel are representatives of the class and will fairly and adequately protect the interests of the class, meaning the specific people, the plaintiffs in this case that have sued, that they will fairly and adequately protect the interests of the entire class, that again, they may not be before Judge LaPlante in New Hampshire, but when you certify this provisional class, it affords protections to anybody that would fall within this proposed class. So that's the cool thing about a class action and its power and its effect. So the judge grants the motion and provisionally certifies the following class for purposes of the preliminary injunction, that nationwide injunction we're about to talk about, for purposes of that preliminary injunctive relief. All current and future persons who were born on or after February 20th, 2025. Stop. So why is that date important? Remember, this was a January 20th executive order. It had a 30-day window that we talked about here. It'll apply only to persons who are born within the U.S. after 30 days from the date. So that is why Judge LaPlante says this applies to current and future persons, as in babies who are yet to be born, who are born on or after February 20th, 2025, or those that have already been born since February 20th, 2025, where, 1, that person's mother was unlawfully present, ... and 2. So what does that mean? It tracks the language of Trump's executive order. So this provisional class certification are for the members that meet whatever that executive order was going after, and more specifically, the babies. So what does that mean? That means Judge LaPlante did not give class membership to all of the plaintiffs that were being seeking this relief, meaning it wasn't to the adults, it wasn't to the parents, it was to the babies. So that's a distinction here, right? That means that it is a narrowed class than what was originally being sought. Still a win, but still a narrowed class, which is kind of what the government, the Trump administration, was actually arguing. They actually told this judge that the class shouldn't be granted and that it was way too broad. And the judge, in part, agreed with the Trump administration. But again, still a win to get this class certification for this group. Let's move on quickly to the actual order that grants that nationwide injunction. The order says, order granting petitioner's motion for a class-wide preliminary injunction. The court grants petitioner's motion for a class-wide preliminary injunction. The court finds that the petitioners have demonstrated a likelihood of success on the merits of their claims. They are likely to suffer irreparable harm if the order is not granted. The potential harm to the class petitioners if the order is not granted outweighs the potential harm to the government if the order is granted, and the issuance of this order is in the public interest. Now, this is pursuant to Federal Rule of Civil Procedure 65A. That's the one that deals with injunctions, and it pretty much blocks a whole list of federal agencies: Department of Homeland Security, Kristi Noem as the Secretary, Department of State, Secretary Marco Rubio of the Department of State, the Department of Agriculture, the Secretary of Agriculture, the Centers for Medicare and Medicaid Services, the Administrator for the Centers of Medicare and Medicaid Services, in their official capacities are, quote, enjoined and restrained from enforcing the executive order protecting the meaning and value of American citizenship, the one that you and I just walked through. The court requires a nominal bond of $1. So a bond has to be posted by the prevailing party in the injunctive space, but $1 is easily met, which is great, right? That nominal bond means that it satisfies the rule of the civil procedure, a federal rule of civil procedure, but it's not something that's going to be cost prohibitive, which is great. This preliminary injunction is stayed for 7 days pending appeal. We've already walked through this. We know that the judge is giving the Trump administration 7 days to appeal. And it says the certified class has been narrowed by the court from that requested by the petitioners. That's a footnote, and that's what we just talked about. The original class as sought by the plaintiffs was much bigger. It's been narrowed by this judge, which, by the way, makes it more likely to survive an appellate review. Now, there's a couple of other things that I want to mention here, right? After this ruling, NBC News went to the Department of Justice to get a statement. And this was what the Department of Justice did. It referred NBC News to a previous statement that was made by Attorney General Pam Bondi last week after a judge in D.C. blocked Trump's asylum ban at the U.S.-Mexico border. This is what the DOJ's response was to what just happened right now in New Hampshire. A rogue district court judge is already trying to circumvent the Supreme Court's recent ruling against nationwide injunctions, end quote. They never learn, do they? There is a slew of federal district court judges and appellate court judges that are telling this administration that they're messing up and that what they're doing is illegal and unconstitutional, but they don't care. And in response, they just call them rogue judges. I mean, it's the lack of respect is one thing, but again, we see continued non-compliance. And so obviously we have to watch what happens very carefully, but what a win. And for your information, the name of this case is Barbara, in quotes, clearly, the name of one of the plaintiffs, Barbara versus Trump, or Barbara versus the United States here. I want to just underscore how important this decision is. We were all wondering what was going to happen post United States Supreme Court's ruling at the end of June concerning nationwide injunctions. There was a lot of uncertainty, and the idea of a class action succeeding was really kind of something we were watching carefully to see if we were going to be able to successfully get across at least the preliminary finish line, the first hurdle. And we've now seen a very smart federal judge say, not only do you get your class certification, but I'm going to enter that nationwide injunction. So this kind of further explains that Supreme Court decision, meaning nationwide injunctions aren't dead. As you recall, the Supreme Court said nationwide injunctions are still available if it provides complete relief, right? If this is an idea that complete relief can only be given through a nationwide injunction. And that's what Amy Coney Barrett underscored in the majority opinion from SCOTUS. So this federal judge says this nationwide injunction is the way to give complete relief, especially to a specific class of people. Folks, we have a class action certified in a birthright citizenship case. We have a nationwide injunction now in a birthright citizenship case. We've got justice and democracy prevailing today. We take our wins where we get them. This is a win for democracy. Be mad, be outraged, demand accountability. These plaintiffs did. Let's watch this space and let's see what else happens. See you on the other side. Katie Phang here. The truth matters now more than ever. So hit that subscribe button so you don't miss a thing. Thanks for watching.